My name is Dave Higgins. I am what I like to describe as a failed actor in Austin, Texas. It went okay for a little while. I got married. Done.
Yeah, blame it on me.
Yeah. To my right, we've got Sarah Clough, Vice President and HRS. Then next we have Shannon McCormick, voiceover actor, live actor, producer, director, all around super amazing stand-up guy. I'm really proud to have with us tonight. And next to him we got Kelly Bland, another phenomenal actress, voiceover actress. She's also a costume designer. She did her first feature film. Woo! She looks a little tired, that is why. And then we have Tony Weber, who is the treasurer of Indivisible Austin. Thank you all for being here. And then last and certainly most, we've got Sarah Holgraffer up in the... She has been the driving force behind this. She's done all of the legwork that all of you are not getting to see. She's amazingly driven and wonderfully positive. Thank you for doing all the work.
And an amazing person to boot. Oh, thanks, guys.
So, on that note, we shall begin reading this final bit of the Mueller Report. I'm just going to do me, as they say. So, we were in Section K, the President's Conduct involving Michael Cohen. The President's conduct involving Michael Cohen spans the full period of our investigation. During the campaign, Cohen pursued the Trump Tower Moscow project on behalf of the Trump Organization. Cohen briefed candidate Trump on the project numerous times, including discussing whether Trump should travel to Russia to advance the deal. After the media began questioning Trump's connections to Russia, Cohen promoted a, quote, party line that publicly distanced Trump from Russia and asserted he had no business there. Cohen continued to adhere to that party line in 2017 when Congress asked him to provide documents and testimony in its Russia investigation. In an attempt to minimize the president's connections to Russia, Cohen submitted a letter to Congress falsely stating that he only briefed Trump on the Trump Tower Moscow project 3 times, that he did not consider asking Trump to travel to Russia, that Cohen had not received a response to an outreach he made to the Russian government, and that the project ended in January 2016, before the first Republican caucus or primary. While working on the congressional statement, Cohen had extensive discussions with the president's personal counsel, who, according to Cohen, said that Cohen should not contradict the president and should keep the president publicly asserted, personal counsel, who, according to Cohen, said that Cohen should not contradict the president and should keep the statement short and, quote, tight. After the FBI searched Cohen's home and office in April 2018, the president publicly asserted that Cohen would not let and privately pass messages of support to him. Cohen also discussed pardons with the president's personal counsel and believed that if he stayed on message, he would get a pardon where the president would do, quote, something else, end quote, to make the investigation end. But Cohen began cooperating with the government in July 2018. The president publicly criticized him, called him a, quote, rat, and suggested his family members had committed crimes.
Evidence. Subsection 1. Candidate Trump's awareness of and involvement in the Trump Tower Moscow project. The president's interactions with Cohen as a witness took place against the background of the president's involvement in the Trump Tower Moscow project. As described in detail in Volume 1, Section 4.A, from September 2015 until at least June 2016, the Trump Organization pursued a Trump Tower Moscow project in Russia, with negotiations conducted by Cohen, then Executive Vice President of the Trump Organization and Special Counsel to Donald J. Trump. The Trump Organization had previously and unsuccessfully pursued a building project in Moscow. According to Cohen, in approximately September 2015, he obtained internal approval from Trump to negotiate on behalf of the Trump Organization to have a Russian corporation build a tower in Moscow that licensed the Trump name and brand. Cohen thereafter had numerous brief conversations with Trump about the project. Cohen
2015, Trump signed a letter of intent for the project that specified highly lucrative terms for the Trump organization. In December 2015, Felix Sater, who was handling negotiations between Cohen and the Russian corporation, asked Cohen for a copy of his and Trump's passports to facilitate travel to Russia to meet with government officials and possible financing partners. Cohen recalled discussing the trip with Trump and requesting a copy of Trump's passport from Trump's personal secretary, Rona Graff. By January 2016, Cohen had become frustrated that Sater had not set up a meeting with Russian government officials. So Cohen reached out directly by email to the office of Dmitry Peskov, who was Putin's deputy chief of staff and press secretary. On January 20th, 2016, Cohen received an email response from Elena Polyakova, Peskov's personal assistant, and phone records confirmed that they then spoke for approximately 20 minutes, during which Cohen described the Trump Tower Moscow project and requested assistance in moving the project forward. Cohen recalled briefing candidate Trump about the call soon afterwards. Cohen told Trump that he spoke with a woman he identified as, quote, someone from the Kremlin, and Cohen reported that she was very professional and asked detailed questions about the project. Cohen recalled telling Trump he wished the Trump organization had assistants who were as competent as the woman from the Kremlin.
Cohen thought his phone call renewed interest in the project. The day after Cohen's call with Polyakova, Sater texted Cohen asking him to, quote, call me when you have a few minutes to chat, ... It's about Putin, they called today. Sater told Cohen that the Russian government liked the project and on January 25th, 2016, sent an invitation for Cohen to visit Moscow, quote, for a working visit, unquote. After the outreach from Sater, Cohen recalled telling Trump that he was waiting to hear back on moving the project forward. After January 2016, Cohen continued to have conversations with Sater about Trump Tower Moscow and continued to keep candidate Trump updated about those discussions and the status of the project. Footnote 927. In later congressional testimony, Cohen stated that he briefed Trump on the project approximately 6 times after January 2016. Cohen recalled that he and Trump wanted Trump Tower Moscow to succeed and that Trump never discouraged him from working on the project because of the campaign. In March or April 2016, Trump asked Cohen if anything was happening in Russia. Cohen also recalled briefing Donald Trump Jr. in the spring, a conversation that Cohen said was not idle chit-chat because Trump Tower Moscow was potentially a $1 billion deal.
Raise it. Cohen recalled that around May 2016, he again raised with candidate Trump the possibility of a trip to Russia to advance the Trump Tower project, Trump Tower Moscow project. At that time, Cohen had received several texts from Sater seeking to arrange dates for such a trip. On May 4th, 2016, Sater wrote to Cohen, I had a chat with Moscow. Assuming the trip does happen, the question is before or after the convention. Obviously, the preempting trip you only can happen anytime you want. But the two big guys is the question. I said I would confirm and revert. This is all direct quote. I don't know exactly. Cohen responded, my trip before Cleveland. Trump once he becomes the nominee after the convention. On May 5th, 2016, Sater followed up with a text that Cohen thought he probably read to Trump.
Peskov would like to invite you as his guest to the St. Petersburg Forum, which is Russia's Davos. It's June 16-19. He wants to meet there with you, possibly introduce you to either Putin or Medvedev. This is perfect. The entire business class of Russia will be there as well. He said anything you want to discuss, including dates and subjects, are on the table to discuss.
Cohen recalled discussing the invitation to the St. Petersburg Economic Forum with candidate Trump and saying that Putin or Russian Prime Minister Dmitry Medvedev might be there. Cohen remembered that Trump said that he would be willing to travel to Russia if Cohen could lock and load on the deal. In June 2016, Cohen decided to attend the St. Petersburg Economic Forum because Sater had not obtained a formal invitation from Cohen from Peskov. Cohen said he had a quick conversation with Trump at the time, but did not tell him that the project was over because he did not want Trump to complain that the deal was on again, off again, if it were revived. During the summer 2016, Cohen recalled that candidate Trump publicly claimed that he had nothing to do with Russia, and then shortly afterwards privately checked with Cohen about the status of the Trump Tower Moscow project, which Cohen found, quote unquote, interesting. At some point that summer, Cohen recalled having a brief conversation with Trump in which Cohen said the Trump Tower Moscow project was going nowhere because the Russian development company had not secured a piece of property for the project. Trump said that was, quote, too bad, and Cohen did not recall talking with Trump about the project after that. Cohen said that at no time during the campaign did Trump tell him not to pursue the project or that the project should be abandoned.
2. Cohen determines to adhere to a party line, distancing candidate Trump from Russia. As previously discussed, when questions about possible Russian support for candidate Trump emerged during the 2016 presidential campaign, Trump denied having any personal, financial, or business connections to Russia, which Cohen described as, quote, the party line, or, quote, message, to follow for Trump and his senior advisors. After the election, the Trump Organization sought to formally close out certain deals in advance of the inauguration. Cohen recalled that Trump Tower Moscow was on the list of deals to be closed out. In approximately January 2017, Cohen began receiving inquiries from the media about Trump Tower Moscow, and he recalled speaking to the president-elect when those inquiries came in. Cohen was concerned that truthful answers about the Trump Tower Moscow project might not be consistent with the, quote, message that the president-elect had no relationship with Russia. In an effort to, quote, stay on message, Cohen told a New York Times reporter that the Trump Tower Moscow deal was not feasible and had ended in January 2016. Cohen recalled that this was part of a script or talking points he had developed with the president-elect and others to dismiss the idea of substantial connection between Trump and Russia. Cohen said that he discussed the talking points with Trump, but that he did not explicitly tell Trump he thought they were untrue because Trump already knew they were untrue. Cohen thought it was important to say the deal was done in January 2016 rather than acknowledge that talks continued in May and June 2016 because it limited the period when candidate Trump could be alleged to have a relationship with Russia to an early point in the campaign before Trump had become the party's presumptive nominee.
Section 3. Cohen submits false statements to Congress minimizing the Trump Tower Moscow project in accordance with the party line. In early May 2017, Cohen received requests from Congress to provide testimony and documents in connection with congressional investigation of Russian interference in the 2016 election. At that time, Cohen understood Congress's interest in him to be focused on the allegations in the Steele report concerning a meeting Cohen allegedly had with Russian officials in Prague during the campaign. Cohen had never traveled to Prague and was not concerned about those allegations, which he believed were provably false. On May 18, 2017, Cohen met with the president to discuss the request from Congress, and the president instructed Cohen that he should cooperate because there was nothing there. Cohen eventually entered into a joint defense agreement with the president and other individuals who were part of the Russia investigation. In the months leading up to his congressional testimony, Cohen frequently spoke with the president's personal counsel. Cohen said that in those conversations, the president's personal counsel would sometimes say that he had just been with the president. Cohen recalled that the president's personal counsel told him the JDA was working well together and assured him that there was nothing there, and if they stayed on message, the investigations would come to an end soon. At that time, Cohen's legal bills were being paid by the Trump Organization, and Cohen was told not to worry because the investigations would be over by summer or fall of 2017. Cohen said that the president's personal counsel also conveyed that, as part of the JDA, Cohen was protected, which he would not be if he, quote, went rogue. Cohen recalled that the president's personal counsel reminded him that, quote, the president loves you, end quote, and told him that if he stayed on message, the president would have his back.
In August 2017, Cohen began drafting a statement about Trump Tower Moscow to submit to Congress along with his document production. The final version of the statement contained several false statements about the project. First, although the Trump Organization continued to pursue the project until at least June 2016, the statement said the proposal was under consideration at the Trump Organization from September 2015 until the end of January 2016. By the end of January 2016, I determined that the proposal was not feasible for a variety of business reasons and should not be pursued further. Based on my business determinations, the Trump Organization abandoned the proposal. End quote. Oh, yeah. Second, although Cohen and candidate Trump had discussed possible travel to Russia by Trump to pursue the venture, the statement said, quote, despite overtures by Mr. Sater, I never considered asking Mr. Trump to travel to Russia in connection with this proposal. I told Mr. Sater that Mr. Trump would not travel to Russia unless there was a definitive agreement in place. End quote. Third, although Cohen had regularly briefed Trump on the status of the project and had numerous conversations about it, the statement said, quote, Mr. Trump was never in contact with anyone about this proposal other than me on 3 occasions, including signing a non-binding letter of intent in 2015, end quote. Fourth, although Cohen's outreach to Peskov in January 2016 had resulted in a lengthy phone call with a representative from the Kremlin, the statement said that Cohen did, quote, not recall any response to my email to Peskov, nor any other contacts by me with Mr. Peskov or other Russian government officials about the proposal.
Cohen's statement was circulated in advance to and edited by members of the JDA. Before the statement was finalized, early drafts contain a sentence stating, quote, the building project led me to make limited contacts with Russian government officials, unquote. In the final version of the statement, that line was deleted. Cohen thought he was told that it was a decision of the JDA to take out that sentence, and he did not push back on the deletion. Cohen recalled that he told the president's personal counsel that he would not contest the decision of the JDA. Cohen also recalled that in drafting a statement for Congress, he spoke to the president's personal counsel about a different issue that connected candidate Trump to Russia, Cohen's efforts to set up a meeting between Trump and Putin in New York during the 2015 United Nations General Assembly. In September 2015, Cohen had suggested the meeting to Trump, who told Cohen to reach out to Putin's office about it. Cohen spoke and emailed with a Russian official about a possible meeting, and recalled that Trump asked him multiple times for updates on the proposed meeting with Putin. When Cohen called the Russian official a second time, she told him it would not follow proper protocol for Putin to meet with Trump, and Cohen relayed that message to Trump. Cohen anticipated he might be asked questions about the proposed Trump-Putin meeting when he testified before Congress, because he had talked about the potential meeting on Sean Kennedy's radio show. Cohen recalled explaining to the president's personal counsel the, quote, whole story, unquote, of the attempt to set up a meeting between Trump and Putin and Trump's role in it. Cohen recalled that he and the president's personal counsel talked about keeping Trump out of the narrative, and the president's personal counsel told Cohen the story was not relevant and should not be included in the statement to Congress.
Cohen said that it was his, quote, agenda in submitting the statement to Congress with false representations about the Trump Tower Moscow project was to minimize links between the project and the president, give the false impression that the project had ended before the first presidential primaries, and shut down further inquiry into the Trump Tower Moscow with the aim of limiting the ongoing Russia investigation. Cohen said he wanted to protect the president and be loyal to him by not contradicting anything the president said. Cohen recalled that he was concerned that if he told the truth about getting a response from the Kremlin or speaking to candidate Trump about travel to Russia to pursue the project, he would contradict the message that no connection existed between Trump and Russia. And he rationalized his decision to provide false testimony because the deal never happened. He was not concerned that the story would be contradicted by individuals who knew it was false, because he was sticking to the party line adhered to by the whole group. Cohen wanted the support of the president and the White House, and he believed that following the party line would help put an end to special counsel and congressional investigations. Between August 18, 2017, and when the statement was in an initial draft stage, and August 28, 2017, when the statement was submitted to Congress, phone record reflected Cohen spoke with the president's personal counsel almost daily. On August 27, 2017, the day before Cohen submitted the statement to Congress, Cohen and the president's personal counsel had numerous contacts by phone, including calls lasting 3, 4, 6, 11, and 18 minutes. Cohen recalled telling the president's personal counsel, who did not have firsthand knowledge of the project that there was more detail on Trump Tower Moscow that was not in the statement, including that there were more communications with Russia and more communications with candidate Trump than the statement reflected. Cohen stated that the president's personal counsel responded that it was not necessary to elaborate or include those details because the project did not progress, and that Cohen should keep the statement short and quote tight. And the matter would soon come to an end. Cohen recalled that the president's personal counsel said his client appreciated Cohen, and that Cohen should stay on message and not contradict the president. That there was no need to muddy the water, and that it was time to move on. Cohen said he agreed because it was what he was expected to do. After Cohen later pleaded guilty to making false statements to Congress about the Trump Tower Moscow project, this office sought to speak with the president's personal counsel about the conversation with Cohen, but counsel declined, citing potential privilege concerns.
At the same time that Cohen finalized his written submission to Congress, he served as a source for a Washington Post story published on August 27, 2017, that reported in depth for the first time that the Trump organization was, quote, pursuing a plan to develop a massive Trump Tower in Moscow, end quote, at the same time as candidate Trump was, quote, running for president in late 2015 and early 2016, end quote. The article reported that, quote, the project was abandoned at the end of January 2016, just before the presidential primaries began. Several people familiar with the proposal said, end quote. Cohen recalled that in speaking to the Post, he held to the false story that negotiations for the deal ceased in January 2016. On August 28, 2017, Cohen submitted his statement about the Trump Tower Moscow project to Congress. Cohen did not recall talking to the president about the specifics of what the statement said or what Cohen would later testify to about Trump Tower Moscow. He recalled speaking to the president more generally about how he planned to stay on message in his testimony. On September 19, 2017, in anticipation of his impending testimony, Cohen orchestrated the public release of his opening remarks to Congress, which criticized the allegations in the Steele material and claimed that Trump Tower Moscow project was, quote, was terminated in January 2016, which occurred before the Iowa caucus and months before the very first primary, end quote. Cohen said the release of his opening remarks was intended to shape the narrative and let other people who might be witnesses know what Cohen was saying so they could follow the same message. That's pretty shit. Cohen said his decision was meant to mirror Jared Kushner's, an upstanding citizen, his decision to release a statement in advance of Kushner's congressional testimony, which the president's personal counsel had told Cohen the president liked. Thumbs up. Cohen recalled that on September 20th, 2017, after Cohen's opening remarks, he had been printed by the media. The president's personal counsel told him that the president was pleased with the Trump Tower Moscow statement that had gone out. On October 24th and 25th, 2017, Cohen testified before Congress and repeated the false statements he had included in his written statement about Trump Tower Moscow. Phone records show that Cohen spoke with the president's personal counsel immediately after his testimony on both days. Subsection 4. The president sends messages of support to Cohen. In January 2018, the media reported that Cohen had arranged a $130,000 payment during the campaign to prevent a woman from publicly discussing an alleged sexual encounter she had with the president before he ran for office. This office did not investigate Cohen's campaign period payments to women, plural, women. You got a footnote, 1008. The office was authorized to investigate Cohen's establishment in use of Essential Consultants, LLC, which Cohen created to facilitate the $130,000 payment during the campaign, based on evidence that the entity received funds from Russian-backed entities. Cohen's use of Essential Consultants to facilitate the $130,000 payment to the woman during the campaign was part of the office's referral of certain Cohen-related matters to the U.S. Attorney's Office for the Southern District of New York. However, those events as described here are potentially relevant to the president's and his personal counsel's interactions with Cohen as a witness who later began to cooperate with the government. On February 13, 2018, the day before Valentine's Day, Cohen released a statement to news organizations that stated, quote, in a private transaction in 2016, I used my own personal funds to facilitate a payment of $130,000 to the woman. Neither the Trump organization nor the Trump campaign was a party to the transaction with the woman, and neither reimbursed me for the payment, either directly or indirectly, end quote. in congressional testimony on February 27, days after Valentine's Day 2019, Cohen testified that he has discussed what to say about the payment with the president, and that the president had directed Cohen to say that the president was, quote, not knowledgeable of his actions, end quote, in making the payment. On February 19, 2018, the day after the New York Times wrote a detailed story attributing the payment to Cohen and describing Cohen as the president's, quote, fixer, Cohen received a text message from the president's personal counsel that stated, quote, client says thanks for what you do, end quote.
That same year, on April 9th, 2018, FBI agents working with the U.S. Attorney's Office for the Southern District of New York executed search warrants on Cohen's home, hotel room, and office. That day, the president spoke to reporters and said that he had, quote, just heard that they broke into the office of one of my personal attorneys, a good man, end quote. The president called the searches, quote, a real disgrace, end quote, and said, it's an attack on our country in a true sense. It's an attack on what we all stand for, end quote. Cohen said that after the searches, he was concerned that he was, quote, an open book, but that he did not want issues arising from the payments to women to come out, and that his false statements to Congress were, quote, a big concern. A few days after the searches, the president called Cohen. According to Cohen, the president said he wanted to, quote, check in and asked if Cohen was okay. And the president encouraged Cohen to, quote, hang in there and stay strong, end quote. Cohen also recalled that following the searches, he heard from individuals who were in touch with the president and relayed to Cohen the president's support for him. Cohen recalled that, redacted, a friend of the president's reached out to say that he was, quote, with the boss in Mar-a-Lago, and the president had said, quote, he loves you and not to worry. Cohen recalled that, redacted, for the Trump organization told him, quote, the boss loves you. And Cohen said that, redacted, a friend of the president's told him everybody knows the boss has your back, unquote. This is how monsters speak.
On or about April 17th, 2018, Cohen began speaking with an attorney, Robert Costello, who had a close relationship with Rudolph Giuliani, one of the president's personal lawyers. Costello told Cohen that he had, quote, a back channel of communications to Giuliani, and that Giuliani had said the channel was crucial and must be maintained. On April 20th, 2018, the New York Times published an article about the president's relationship with and treatment of Cohen. The president responded with a series of tweets predicting that Cohen would not, quote, flip.
The New York Times and the third-rate reporter are going out of their way to destroy Michael Cohen and his relationship with me in the hope that he will flip. They use non-existent sources and a drunk/drugged-up loser who hates Michael, a fine person with a wonderful family. Michael is a businessman for his own account/lawyer who I have always liked and respected. Most people will flip if the government lets them out of trouble, even if it means lying or making up stories. Sorry, I don't see Michael doing that, despite the horrible witch hunt and the dishonest media.
In an email that day to Cohen, Costello wrote that he had spoken with Giuliani. Costello told Cohen that the conversation was, quote, very, very positive. You are loved. They are in our corner. Sleep well tonight. You have friends in high places. Cohen said that following these messages, he believed he had the support of the White House and he continued to toe the party line. And he determined to stay on message and be part of the team. At the time, Cohen understood that his legal fees were still being paid by the Trump organization, which he said was important to him. Cohen believed he needed the power of the president to take care of him, so he needed to defend the president and stay on message.
Cohen said that following these messages, he believed he had the support of the White House if he continued to. Cohen also recalled speaking with the president's personal counsel about pardons after the searches of his home and office had occurred, at a time when the media had reported that pardon discussions were occurring at the White House. Footnote 1031. At a White House press briefing on April 23, 2018, in response to a question about whether the White House had, quote, closed the door one way or the other on the president pardoning Michael Cohen, quote, Sanders said, quote, quote, it's hard to close the door on something that hasn't taken place. I don't like to discuss or comment on hypothetical situations that may or may not ever happen. I would refer you to personal attorneys to comment on anything specific regarding that case, but we don't have anything at this point, unquote. Sarah Sanders, White House Daily Briefing. Cohen told the president's personal counsel he had been a loyal lawyer and servant, and he said that after the searches he was in an uncomfortable position and wanted to know what was in it for him. According to Cohen, the president's personal counsel responded that Cohen should stay on message, that the investigation was a witch hunt, and that everything would be fine. Cohen understood, based on this conversation and previous conversations about pardons with the president's personal counsel, that as long as he stayed on message, he would be taken care of by the president, either through a pardon or through the investigation being shut down. On April 24th, 2018, the president responded to a reporter's inquiry whether he would consider a pardon for Cohen with, quote, stupid question, unquote. On June 8th, 2018, the president said he, quote, hadn't even thought about, quote, pardons for Manafort or Cohen, and continued, quote, it's far too early to be thinking about that. They haven't been convicted of anything. There's nothing to pardon. And on June 15, 2018, the president expressed sympathy for Cohen, Manafort, and Flynn in a press interview and said, quote, I feel badly about a lot of them because I think a lot of it is very unfair, unquote.
The president's conduct after Cohen began cooperating with the government. On July 2nd, 2018,
It's different. That was
yeah. On July 2nd, 2018, ABC News reported that, based on an, quote, exclusive interview with Cohen, that Cohen, quote, strongly signaled his willingness to cooperate with Special Counsel Robert Mueller and federal prosecutors in the Southern District of New York, even if that puts President Trump in jeopardy, unquote. That week, the media reported that Cohen had added an attorney to his legal team who previously had worked as a legal advisor to President Bill Clinton. Press conference. Beginning on July 20th, 2018, the media reported on the existence of a recording Cohen had made of a conversation he had with candidate Trump about a payment made to a second woman who said she had an affair with Trump. On July 21st, 2018, the president responded, inconceivable that the government would break into a lawyer's office early in the morning. Almost unheard of. Even more inconceivable that a lawyer would tape a claim. Totally unheard of, and perhaps illegal. The good news is that your favorite president did nothing wrong. That's my best comment. On July 27, 2018, after the media reported that Cohen was willing to inform investigators that Donald Trump Jr. told his father about the June 9th, 2016 meeting to get, quote, dirt on, unquote, on Hillary Clinton, the president tweeted, so the fake news doesn't waste time with dumb questions. No, I did not know of the meeting with my son Don Jr. Sounds to me like someone is trying to make up stories in order to get himself out of an unrelated jam. Taxi cabs, maybe? He even retained Bill and Crooked Hillary's lawyer. Gee, I wonder if they helped him make the choice.
On August 21st, 2018, Cohen pleaded guilty in the Southern District of New York to 8 felony charges, including 2 counts of campaign finance violations based on the payments he made during the final weeks of the campaign to women who said they had had affairs with the president. During the plea hearing, Cohen stated that he had worked, quote, at the direction of, end quote, the candidate in making those payments. The next day, the president contrasted Cohen's cooperation with Manafort's refusal to cooperate, tweeting, quote, I feel very badly for Paul Manafort and his wonderful family. Justice took a 12-year-old tax case, among other things, applied tremendous pressure on him, and unlike Michael Cohen, he refused to make up stories in order to get a deal, such respect for a brave man, end quote. Trump is also not that good. On September 17, 2018, this office submitted written questions to the president that included questions about the Trump Tower Moscow project and attached Cohen's written statement to Congress and the letter of intent signed by the president. Among other issues, the questions asked the president to describe the timing and substance of discussions he had with Cohen about the project, whether they discussed a potential trip to Russia, and whether the president, quote, at any time directed or suggested that discussions about the Trump Tower Moscow project should cease, end quote, or whether the president was, quote, informed at any time that the project had been abandoned, end quote. On November 20th, 2018, the president submitted written responses that did not answer those questions about Trump Tower Moscow directly and did not provide any information about the timing of the candidate's discussions with Cohen about the project or whether he participated in any discussions about the project being abandoned or no longer pursued. Instead, the president's answers stated in relevant part.
I'm not even going to try to do a voice. Quote, I had few conversations with Mr. Cohen on this subject. As I recall, they were brief and they were not memorable. I was not enthused about the proposal, and I do not recall any discussion of travel to Russia in connection with it. I do not remember discussing it with anyone else at the Trump Organization, although it is possible. I do not recall being aware at the time of any communications between Mr. Cohen and Felix Sater and any Russian government officials regarding the letter of intent.
On November 29th, 2018, Cohen pleaded guilty to making false statements to Congress based on his statements about the Trump Tower Moscow project. In a plea agreement with this office, Cohen agreed to, quote, provide truthful information regarding any and all matters to which this office deems relevant, end quote. Later on November 29th, after Cohen's guilty plea had become public, the president spoke to reporters about the Trump Tower Moscow project, saying,
We have a bingo. Right?
Oh, we got a bingo? Yeah! No, you did not have a bingo?
No, I do. I just said not what he said.
Yeah, no, but
Oh,
right.
Right, yeah. This is the whole experience. Welcome to our entire intent. Oh, it's not.
Taking my time.
Yeah. Please keep persisting.
The lovely Sarah Holgreavers.
We suggest inviting friends over, getting a good bottle of absinthe, reading it to each other, and crying uncontrollably in each other's arms. And then interspersed with the giggles.
Right. So
Okay. Okay, so, to pick it up, let's see, later on, November 29th, after Cohen's guilty plea had become...
The box item.
No, I know. Yeah, okay. I was adding context, but I'll keep going. Okay, so Trump says, I decided not to do the project. I decided ultimately not to do it. There would have been nothing wrong if I did do it. If I did do it, there would have been nothing wrong. That was my business. It was an option that I decided not to do. I decided not to do it. Very heavily. The primary reason, I was focused on running for president. I was running my business while I was campaigning. There was a good chance that I wouldn't have won, in which case I would have gone back into the business. And why should I lose lots of opportunities? He didn't want to win, y'all. He didn't want to win.
I also think that another fun game is to take all of these quotes and apply them to Jimmy Carter's peanut farm. And we can all have a real good one. The president also said that Cohen was, quote, a weak person. And by being weak, unlike other people that you watch, he is a weak person. And what he's trying to do is get a reduced sentence. So he's lying about a project that everybody knew about, end quote. The president also brought up Cohen's written submission to Congress regarding the Trump Tower Moscow project. Quote, so here's the story. Go back and look at the paper that Michael Cohen wrote before he testified in the House and the Senate. It talked about his position, end quote. The president added, quote, even if he was right, it doesn't matter because I was allowed to do whatever I wanted during the campaign.
Which is false. In light of the president's public statements following Cohen's guilty plea that he, quote, decided not to do the project, end quote, this office again sought information from the president about whether he participated in any discussion about the project being abandoned or no longer pursued, including when he, quote, decided not to do the project, end quote, who he spoke to about that decision, and what motivated that decision. The office also again asked for the timing of the president's discussions with Cohen about the Trump Tower Moscow project and asked him to specify, quote, what period of the campaign he was involved in discussion concerning the project. In response, the president's personal counsel declined to provide additional information from the president and stated that, quote, the president has fully answered the questions at issue, end quote. In the weeks following Cohen's plea, an agreement to provide assistance to this office, the president repeatedly implied that Cohen's family members were guilty of crimes. On December 3rd, 2018, after Cohen had filed his sentencing memorandum, the president tweeted, quote, Michael Cohen asks judge for no prison time. You mean he can do all of the terrible, unrelated to Trump things having to do with fraud, big loans, taxis, etc., and not serve a long prison term? He makes up stories to get a great and already reduced deal for himself and get his wife and father-in-law, who has the money, off scot-free. He lied for this outcome and should, in my opinion, serve a full and complete sentence. End quote. Redacted due to harm to ongoing matter.
On December 12, 2018, Cohen was sentenced to 3 years of imprisonment. The next day, the president sent a series of tweets that said,
I never directed Michael Cohen to break the law. Those charges were just agreed to by him in order to embarrass the president and get a much-reduced prison sentence, which he did, including the fact that his family was temporarily let off the hook. As a lawyer, Michael has great liability to me.
On December 16, 2018, the president tweeted, quote, remember, Michael Cohen only became a rat after the FBI did something which was absolutely unthinkable and unheard of until a witch hunt was illegally started. They broke into an attorney's office. Why didn't they break into the DNC to get the server or Crooked's office?
Oh, Hillary. He means Hillary.
Yeah, that's what we mean. In January 2019, after the media reported that Cohen would provide public testimony in a congressional hearing, the president made additional public comments suggesting that Cohen's family members had committed crimes. In an interview on Fox on January 12, 2019, the president was asked whether he was worried about Cohen's testimony and responded,
In order to get his sentence reduced, Cohen says, I have an idea. I'll give you some information on the president. Well, there is no information, but he should give information maybe on his father-in-law, because that's the one that people want to look at, because where does that money? That's the money in the family. And I guess he didn't want to talk about his father-in-law. He's trying to get his sentence reduced, so it's pretty sad. You know, it's weak and it's very sad to watch a thing like that.
On January 18, 2019, the president tweeted, quote, Kevin Court at Fox News, quote, don't forget Michael Cohen has already been convicted of perjury and fraud, and as recently as this week, the Wall Street Journal has suggested that he may have stolen tens of thousands of dollars, quote, lying to reduce his jail time. Watch father-in-law.
On January 23rd, 2019, Cohen postponed his congressional testimony, citing threats against his family. The next day, the president tweeted, so interesting that bad lawyer Michael Cohen, who sadly will not be testifying before Congress, is using the lawyer of crooked Hillary Clinton to represent him. Gee, how did that happen? Unquote. Also in January 2019, Giuliani gave press interviews that appeared to confirm Cohen's account that the Trump Organization pursued the Trump Tower Moscow project well past January 2016. Giuliani stated that, quote, it's our understanding that discussions about the Trump Moscow project went on throughout 2016. Weren't a lot of them, but there were conversations. Can't be sure of the exact date, but the president can remember having conversations with him about it. The president also remembers, could be up to as far as October, November, unquote. In an interview with the New York Times, Giuliani quoted the president as saying that the discussions regarding the Trump Moscow project were, quote, going on from the day I announced to the day I won, unquote. On January 21st, 2019, Giuliani issued a statement that said, quote, my recent statements about discussions during the 2016 campaign between Michael Cohen and candidate Donald Trump about a potential Trump Moscow project were hypothetical and not based on conversations I had with the president, unquote.
I like going to use the hypothetical conversations I have. So.
Analysis. In analyzing the president's conduct related to Cohen, the following evidence is relevant to the elements of obstruction of justice. A. Obstructive act. We gathered evidence of the president's conduct related to Cohen on two issues. One, whether the president or others aided or participated in Cohen's false statements to Congress. And two, whether the president took actions that would have the natural tendency to prevent Cohen from providing truthful information to the government. 1. First, with regard to Cohen's false statements to Congress. While there is evidence described below that the president knew Cohen provided false testimony to Congress about the Trump Tower Moscow project, the evidence available to us does not establish that the president directed or aided Cohen's false testimony. Cohen said that his statements to Congress followed a, quote, party line approach that developed within the campaign to align with the president's public statements, distancing the president from Russia. Cohen also recalled that in speaking with the president in advance of testifying, he made it clear that he would stay on message, which Cohen believed they both understood would require false testimony. But Cohen said that he and the president did not explicitly discuss whether Cohen's testimony about the Trump Tower Moscow project would be or was false, and the president did not direct him to provide false testimony. Cohen said he did not tell the president about the specifics of his planned testimony. During the time when his statement to Congress was being drafted and circulated to members of the JDA, Cohen did not speak directly to the president about the statement, but rather communicated with the president's personal counsel, as corroborated by the phone records, showing extensive communication between Cohen and the president's personal counsel before Cohen submitted his statement and when he testified before Congress.
Cohen recalled that in his discussions with the president's personal counsel on August 27, 2017, the day before Cohen's statement was submitted to Congress, Cohen said that there were more communications with Russia and more communications with candidate Trump than the statement reflected. Cohen recalled expressing some concern at that time. According to Cohen, the president's personal counsel, who did not have firsthand knowledge of the project, responded by saying that there was no need to muddy the water, that it was unnecessary to include those details because the project did not take place, and that Cohen should keep his statement short and tight, not elaborate, stay on message, and not contradict the president. Cohen's recollection of the content of those conversations is consistent with the direction about the substance of Cohen's draft statement that appeared to come from members of the JDA. For example, Cohen omitted any reference to his outreach to Russian government officials to set up a meeting between Trump and Putin during the United Nations General Assembly, and Cohen believed it was a decision of the JDA to delete the sentence, quote, "The building project led me to make limited contacts with Russian government officials," end quote. The president's personal counsel declined to provide us with his account of his conversations with Cohen, and there's no evidence available to us that indicates that the president was aware of the information Cohen provided to the president's personal counsel. The president's conversations with his personal counsel were presumptively protected by attorney-client privilege, and we did not seek to obtain the contents of any such communications. The absence of evidence about the president and his counsel's conversations about the drafting of Cohen's statement precludes us from assessing what, if any, role the president played. Second, we considered whether the president took actions that would have the natural tendency to prevent Cohen from providing truthful information to criminal investigators or to Congress. Before Cohen began to cooperate with the government, the president publicly and privately urged Cohen to stay on message and not, quote, flip. Cohen recalled the president's personal counsel telling him that he would be protected so long as he did not, quote, go rogue. In the days and weeks that followed the April 2018 searches of Cohen's home and office, the president told reporters that Cohen was a, quote, good man, and said he was, quote, a fine person with a wonderful family, who I have always liked and respected, end quote. Privately, the president told Cohen to, quote, hang in there, and, quote, stay strong. People who were close to both Cohen and the president passed messages to Cohen that, quote, the president loves you, end quote, quote, the boss loves you, end quote, and, quote, everyone knows the boss had your back, end quote. Through the president's personal counsel, the president also had previously told Cohen, quote, thanks for what you do, end quote. After Cohen provided information to the media about payments to women that, according to Cohen, both Cohen and the president knew was false, at that time, the Trump Organization continued to pay Cohen's legal fees, which was important to Cohen. Cohen also recalled discussing the possibility of a pardon with the president's personal counsel, who told him to stay on message and everything would be fine. The president indicated in his public statements that a pardon had not been ruled out, and also stated publicly that, quote, most people will flip if the government lets them out of trouble, end quote, but that he, quote, didn't see Michael doing that, end quote. After it was reported that Cohen intended to cooperate with the government, however, the president accused Cohen of, quote, making up stories in order to get himself out of an unrelated jam. Taxi cabs, maybe? End quote. Called Cohen a, quote, rat, and on multiple occasions publicly suggested that Cohen's family members had committed crimes. The evidence concerning this sequence of events could support an inference that the president used inducements in the form of positive messages in an effort to get Cohen not to cooperate, and then turn to attacks and intimidation to deter the provision of information or undermine Cohen's credibility once Cohen began cooperating. That's normal behavior for a president.
The second element of an obstructive act is B, nexus to an official proceeding. The president's relevant conduct toward Cohen occurred when the president knew the special counsel's office, Congress, and the U.S. Attorney's Office for the Southern District of New York were investigating Cohen's conduct. The president acknowledged through his public statements and tweets that Cohen potentially could cooperate with the government investigations. Third element, C, intent. In analyzing the president's intent in his actions toward Cohen as a potential witness, there is evidence that could support the inference that the president intended to discourage Cohen from cooperating with the government. Okay, I'm going to repeat that. There is evidence that supports the inference that the president intended to discourage Cohen from cooperating because Cohen's information would shed adverse light on the president's campaign period conduct and statements. Subsection 1. Cohen's false congressional testimony about the Trump Tower Moscow project was designed to minimize connections between the president and Russia and to help limit the congressional and DOJ Russia investigations, a goal that was in the president's interest as reflected by the president's own statements. During and after the campaign, the president made repeated statements that he had, quote, no business in Russia, and said that there were, quote, no deals that could happen in Russia because we stayed away, end quote. As Cohen knew, and as he recalled communicating to the president during the campaign, Cohen's pursuit of the Trump Tower Moscow project cast doubt on the accuracy or completeness of these statements.
In connection with his guilty plea, Cohen admitted that he had multiple conversations with candidate Trump to give him status updates about the Trump Tower Moscow project. Those conversations continued through at least June 2016, and that he discussed with Trump possible travel to Russia to pursue the project. The conversations were not offhand, according to Cohen, because the project had the potential to be so lucrative. In addition, text messages to and from Cohen and other records further established that Cohen's efforts to advance the project did not end in January 2016, and that in May and June 2016, Cohen was considering the timing for possible trips to Russia by him and Trump in connection with the project. The evidence could support an inference that the president was aware of these facts at the time of Cohen's false statements to Congress. Cohen discussed the project with the president in early 2017 following media inquiries. Cohen recalled that on September 20th, 2017, the day after he released to the public his opening remarks to Congress, which said the project was, quote, was terminated in January of 2016, the president's personal counsel told him the president was pleased with what Cohen had said about Trump Tower Moscow. And after Cohen's guilty plea, the president told reporters that he had ultimately decided not to do the project, which supports the inference that he remained aware of his own involvement in the project and the period during the campaign in which the project was pursued.
Subsection 2. The president's public remarks following Cohen's guilty plea also suggest that the president may have been concerned about what Cohen told investigators about the Trump Tower Moscow project. At the time, the president submitted written answers to questions from this office about the project and other subjects. The media had reported that Cohen was cooperating with the government, but Cohen had not yet pleaded guilty to making false statements to Congress. Accordingly, it was not publicly known what information about the project Cohen had provided to the government. In his written answers, the president did not provide details about the timing and substance of his discussions with Cohen about the project and gave no indication that he had decided to no longer pursue the project. Yet after Cohen pleaded guilty, the president publicly stated that he had The president then declined to clarify the seeming discrepancy to our office or answer additional questions. The content and timing of the president's provision of information about his knowledge and actions regarding the Trump Tower Moscow project is evidence that the president may have been concerned about the information that Cohen could provide as a witness.
Section 3 under intent. The president's concern about Cohen's cooperating may have been directed at the Southern District of New York's investigation into other aspects of the president's dealings with Cohen rather than the investigation of Trump Tower Moscow. There's also some evidence that the president's concern about Cohen cooperating was based on the president's stated belief that Cohen would provide false testimony against the president in an attempt to obtain a lesser sentence for his unrelated criminal conduct. The president tweeted that Manafort, unlike Cohen, refused to break and make up stories in order to get a deal. And after Cohen pleaded guilty to making false statements to Congress, the president said, what Cohen's trying to do is get a reduced sentence, so he's lying about a project that everybody knew about. But the president also appeared to defend the underlying conduct, saying, even if Cohen was right, it doesn't matter, because I was allowed to do whatever I wanted during the campaign. As described above, there is evidence that the president knew that Cohen had made false statements about the Trump Tower Moscow project, and that Cohen did so to protect the president and minimize the president's connections to Russia during the campaign.
Subsection 4 under intent. Finally, the president's statements insinuating that members of Cohen's family committed crimes after Cohen began cooperating with the government could be viewed as an effort to retaliate against Cohen and chill further testimony adverse to the president by Cohen or others. It is possible that the president believes, as reflected in his tweets, that Cohen, quote, made up stories, end quote, in order to get a deal for himself and, quote, get his wife and father-in-law off scot-free, end quote. It also is possible that the president's mention of Cohen's wife and father-in-law were not intended to affect Cohen as a witness, but rather were part of a public relations strategy aimed at discrediting Cohen and deflecting attention away from the president on Cohen-related matters. What's the fucking difference? But the president's suggestion that Cohen's family members committed crimes happened more than once, including just before Cohen was sentenced. At the same time, the president stated that Cohen, quote, should, in my opinion, serve a full and complete sentence, end quote. And again, just before Cohen was scheduled to testify before Congress. The timing of the statements supports an inference that they were intended, at least in part, to discourage Cohen from further cooperation. L. Overarching factual issues, which looks like, I feel like that could be a subtitle of Trump's presidency. Overarching factual issues. My bad. Although this report does not contain a traditional prosecution decision or declination decision, the evidence supports several general conclusions relevant to analysis of the facts concerning the president's course of conduct. 1. 3 features of this case render it atypical compared to the heartland obstruction of justice prosecutions brought by the Department of Justice. First, the conduct involved actions by the president. Some of the conduct did not implicate the president's constitutional authority and raises garden variety obstruction of justice issues. That can't even be special in that way, which is garden variety. Other events we investigated, however, drew upon the president's Article 2 authority, which raised constitutional issues that we address in Volume 2, Section 3, Part B. We invite you to look it up. A factual analysis of that conduct would have to take into account both that the president's acts were facially lawful and that his position as head of the executive branch provides him with unique and powerful means of influencing official proceedings, subordinate officers, and potential witnesses.
The second atypical aspect is many obstruction cases involve the attempted or actual cover-up of an underlying crime. Personal criminal conduct can furnish strong evidence that the individual had an improper obstructive purpose. See, for example, U.S. v. Willoughby, or that he contemplated an effect on an official proceeding. See, for example, U.S. v. Bidet. But proof of such a crime is not an element of an obstruction offense. See U.S. v. Greer, stating in applying the obstruction sentencing guideline that, quote, obstruction of a criminal investigation is punishable even if the prosecution is ultimately unsuccessful or even if the investigation ultimately reveals no underlying crime, end quote. Obstruction of justice can be motivated by a desire to protect non-criminal personal interests, to protect against investigations where underlying criminal liability falls into a gray area, or to avoid personal embarrassment. The injury to the integrity of the justice system is the same, regardless of whether a person committed an underlying wrong. In this investigation, the evidence does not establish that the president was involved in an underlying crime related to Russian election interference, for lack of evidence. But the evidence does point to a range of other possible personal motives animating the president's conduct. These include concerns that continued investigation would call into question the legitimacy of his election, and potential uncertainty about whether certain events, such as advance notice of WikiLeaks release of hacked information, or the June 9, 2016 meeting between senior campaign officials and Russians, could be seen as criminal activity by the president, his campaign, or his family.
Third, many of the president's acts directed at witnesses, including the discouragement of cooperation with the government and suggestions of possible future pardons, occurred in public view. While it may be more difficult to establish that public-facing acts were motivated by a corrupt intent, the president's power to influence actions, persons, and events is enhanced by his unique ability to attract attention through the use of mass communications. And no principle of law excludes public acts from the scope of obstruction statutes. If the likely effect of the acts is to intimidate witnesses or alter their testimony, the justice system's integrity is equally threatened. 2. Although the events we investigated involved discrete acts, for example, the president's statement to Comey about the Flynn investigation, his termination of Comey, and his efforts to remove the special counsel, it is important to view the president's pattern of conduct as a whole. That pattern sheds light on the nature of the president's acts and the inferences that can be drawn about his intent.
2A. Our investigation found multiple acts by the president that were capable of exerting undue influence over law enforcement investigations, including the Russian interference and obstruction investigations. The incidents were often carried out through one-on-one meetings in which the president sought to use his official power outside of usual channels. These actions ranged from efforts to remove the special counsel and to reverse the effect of the Attorney General's recusal, to the attempted use of official power to limit the scope of the investigation, to direct and indirect contacts with witnesses with the potential to influence their testimony. Viewing the acts collectively can help to illuminate their significance. For example, the president's direction to McGahn to have the special counsel removed was followed almost immediately by his direction to Lewandowski to tell the Attorney General to limit the scope of the Russia investigation to prospective election interference only, a temporal connection that suggests that both acts were taken with a related purpose with respect to the investigation. The president's efforts to influence the investigation were mostly unsuccessful, but that is largely because the persons who surrounded the president declined to carry out orders or accede to his requests. Comey did not end the investigation of Flynn, which ultimately resulted in Flynn's prosecution and conviction for lying to the FBI. McGahn did not tell the acting Attorney General that the special counsel must be removed, but was instead prepared to resign over the president's order. Lewandowski and Dearborn did not deliver the president's message to Sessions that he should confine the Russia investigation to future election meddling only. And McGahn refused to recede from his recollections about events surrounding the president's direction to have the special counsel removed, despite the president's multiple demands that he do so. Consistent with that pattern, the evidence we obtained would not support potential obstruction charges against the president's aides and associates beyond those already filed.
So to clarify, the president ordered the obstruction of justice and his aides just ignored it.
Yeah, they ignored it.
Yes, and so they're not liable because they didn't obstruct justice.
Right. Or nor did they try.
Ordered the obstruction of justice as the president of the United States, and then it didn't happen because people treated him like a child.
So something we've been over in parts 1, 2, and now 3 of our second volume of the book.
Okay, I just want to make sure I was on the right page.
Yeah, you're there. You're picking up what Mueller's putting down.
Cool. In considering the full scope of the conduct we investigated, the President's actions can be divided into two distinct phases, reflecting a possible shift in the President's motives. In the first phase, before the President fired Comey, the President had been assured that the FBI had not opened an investigation of him personally. The President deemed it critically important to make public that he was not under investigation, and he included that information in his termination letter to Comey after other efforts to have that information disclosed were unsuccessful. Soon after he fired Comey, however, the President became aware that investigators were conducting an obstruction of justice inquiry into his own conduct. That awareness marked a significant change in the President's conduct and the start of a second phase of action. The President launched public attacks on the investigation and individuals involved in it who could possess evidence adverse to the President. While in private, the President engaged in a series of targeted efforts to control the investigations. For instance, the President attempted to remove the special counsel. He sought to have Attorney General Sessions unrecuse himself and limit the investigation. He sought to prevent public disclosure of information about the June 9th, 2016 meeting between Russians and campaign officials. And he used public forums to attack potential witnesses who might offer adverse information and to praise witnesses who declined to cooperate with the government. Judgments about the nature of the President's motives during each phase would be informed by the totality of the evidence.
Part 3, legal defenses to the application of obstruction of justice statutes to the President. Might be connected, we're not sure. The President's personal counsel has written to this office to advance statutory and constitutional defenses to the potential application of the obstruction of justice statutes to the President's conduct. As a statutory matter, the President's counsel has argued that a core obstruction of justice statute, 18 U.S. Code subsection 1512C2, does not cover the President's actions. As a constitutional matter, the President's counsel argued that the President cannot obstruct justice by exercising his constitutional authority to close Department of Justice investigations or terminate the FBI director. Under that view, any statute that restricts the President's exercise of those powers would impermissibly intrude on the President's constitutional role. The President's counsel has conceded that the President may be subject to criminal laws that do not directly involve exercises of his Article 2 authority, such as laws prohibiting bribing witnesses or supporting perjury. But counsel has made a categorical argument that, quote, the President's exercise of his constitutional authority here to terminate an FBI director and to close investigations cannot constitutionally constitute obstruction of justice, end quote. In analyzing counsel's statutory arguments, we concluded that the President's proposed interpretation of Section 1512C2 is contrary to the litigating position of the Department of Justice and is not supported by principles of statutory construction. As for the constitutional arguments, we recognize that the Department of Justice and the courts have not definitively resolved these constitutional issues. We therefore analyze the President's position through the framework of Supreme Court precedent addressing the separation of powers. Under that framework, we concluded Article 2 of the Constitution does not categorically and permanently immunize the President from potential liability for the conduct that we investigated.
Can we repeat that?
Yes, of course. Under that framework, we concluded Article 2 of the Constitution does not categorically and permanently immunize the President from potential liability for the conduct that we investigated. Rather, our analysis led us to conclude that the obstruction of justice statutes can validly prohibit a President's corrupt efforts to use his official powers to curtail and or interfere with an investigation.
Amen!
A. I'm not preaching, I'm reading from a government official with years of experience. A. Part A. Statutory defenses to the application of obstruction of justice provisions to the conduct under investigation. So these are the statutory defenses to the shit they were checking out. I'm pretty sure what that says. The obstruction of justice statute, most readily applicable to our investigation, is 18 U.S. Code 1512C2. Section 1512C provides
C. Whoever corruptly 1. Alters, destroys, mutilates, or conceals a record, document, or other object, or attempts to do so with the intent to impair the object's integrity or availability for use in an official proceeding, or 2. Otherwise obstructs, influences, or impedes any official proceeding or attempts to do so, shall be fined under this title or imprisoned not more than 20 years or both.
Yep, didn't think I could. The Department of Justice has taken the position that Section 1512C2 states a broad, independent, and unqualified prohibition on obstruction of justice. While defendants have argued that subsection C2, like we do, should be read to cover only acts that would impair the availability or integrity of evidence, because that is subsection C1's focus, strong arguments weigh against that proposed limitation. The section of Section 512C2 confirms that its sweep is not tethered to Section 512C1. Courts have so interpreted. Its history does not counsel otherwise, and no principle of statutory construction dictates a contrary view. On its face, therefore, Section 512C2 applies to all corrupt means of obstructing a proceeding, pending, or contemplated, including by improper exercises of official power. In addition, other statutory provisions that are potentially applicable to certain conduct we investigated broadly prohibit obstruction of proceedings that are pending before courts, grand juries, and Congress. Congress has also specifically prohibited witness tampering.
Thanks for that. Subsection 1. The text of Section 1512C2 prohibits a broad range of obstructive acts. Broad range. Several textual features of Section 1512C2 support the conclusion that the provision broadly prohibits corrupt means of obstructing justice and is not limited by the more specific prohibitions in the section, which focus on evidence impairment. First, the text of Section 1512C2 is unqualified. It reaches acts that, quote, obstruct, influence, or impede any official proceeding when committed corruptly, end quote. Nothing in Section 1512C2's text limits the provision to acts that would impair the integrity or availability of evidence for use in an official proceeding. In contrast, the section explicitly includes the requirement that the defendant act, quote, with the intent to impair the object's integrity or availability for use in an official proceeding, end quote. A requirement that Congress also included in 2 other sections of Section 1512. But no comparable intent or conduct element focused on evidence of impairment appears in Section 1512C2. The intent element in the section comes from the word, quote, corruptly. See, for example, U.S. v. McKibbins. Quote, the intent element is important because the word corruptly is what serves to separate criminal and innocent acts of obstruction, end quote. And the conduct element in Section 1512C2 is, quote, obstructing, influencing, or impeding a proceeding. Congress is presumed to have acted intentionally in the disparate inclusion and exclusion of evidence impairment language. See Lauren v. U.S. Quote, when Congress includes particular language in one section of a statute but omits it in another, let alone in the very next provision, this court, quote, presumes that Congress intended a difference in meaning, end quote. So basically, they said what they said.
Second, the structure of Section 1512 supports the conclusion that Section 1512C2 defines an independent offense. Section 1512C2 delineates a complete crime with different elements from Section 15C1, and each subsection of Section 15C contains its own attempt prohibition, underscoring that they are independent prohibitions. The 2 subsections of Section 1512C are connected by the conjunction or,
indicating that each provides an alternative basis for criminal liability. In Lowry, for example, the Supreme Court relied on the use of the word "or" to hold that adjacent and overlapping subsections of the bank fraud statute state-to-state offenses, and that subsection 1344(2) therefore should not be interpreted to contain an additional element specified only in subsection 1344(1). And here, as in Lowry, section 1512C, two clauses have separate numbers, line breaks, before, between, and after them, and equivalent indentation, thus placing the clauses visually on an equal footing and indicating that they have separate meanings.
Third, the introductory word. Oh my God, words. Crazy.
This is what law school is for.
I'm a theater major. Okay. Third, the introductory word "otherwise" in section 1512C2 signals that the provision covers obstructive acts that are different from those listed in section 1512C1. See Black's Law Dictionary. Otherwise means in a different manner, in another way, or in other ways. See also American Heritage College Dictionary online. 1, in another way, differently. 2, under other circumstances. See also Gooch v. U.S., characterizing otherwise as a broad term and holding that a statutory prohibition on kidnapping for ransom or reward or otherwise, unquote, is not limited by the words, quote, ransom and, quote, reward to kidnappings for pecuniary benefits.
We tricked everyone. We're not going to read the dictionary. We're here to read the legal dictionary. Surprise!
Clauses v. U.S. Construing otherwise to reach beyond the specific examples listed in prior subsections, thereby covering the, quote, myriad means that human ingenuity might devise to permit a person to avoid the jurisdiction of the court, unquote. The purpose of the word "otherwise" in section 1512C2 is therefore to clarify that the provision covers obstructive acts other than the destruction of physical evidence with the intent to impair its integrity or availability, which is the conduct addressed in section 1512C1. The word "otherwise" does not signal that section 1512C2 has less breadth in covering obstructive conduct than the language of the provision implies.
Yeah.
I'm sorry. Law school!
Yeah.
That's a doozy.
Merriam-Webster defines "otherwise" as, let's see, 2, judicial decisions supporting a broad reading of section 15C2. Courts have not limited section 15C2 to conduct that impairs evidence, but instead have read it to cover obstructive acts in any form. As one court explained, this expansive subsection operates as a catch-all to cover otherwise obstructive behavior that might not constitute a more specific offense like the document destruction, which is listed in C1. United States v. Pendesto, for example, in United States v. Ring, the court rejected the argument that 1512C2's reference to conduct that, quote, otherwise obstructs, influence, or impedes any official proceeding is limited to conduct that is similar to the type of conduct described by subsection C1, namely conduct that impairs the integrity or availability of records, documents, or other objects for use in an official proceeding. The court explained that, quote, the meaning of 1512C2 is plain on its face. All right? And courts have upheld convictions under section 1512C2 that did not involve evidence impairment, but instead resulted from conduct that more broadly thwarted arrests or investigations. See United States v. Martinez. Police officer tipped off suspects about issuance of arrest warrants before, quote, outstanding warrants could be executed, thereby potentially interfering with ongoing grand jury proceeding. United States v. Arnsfield, officer disclosed existence of an undercover investigation to its target. United States versus Phillips, defendant disclosed identity of an undercover officer, thus preventing him from making controlled purchases from methamphetamine dealers.
I got a personal thing going on this here. My last career was methamphetamine.
Oh, congratulations.
Yeah.
corrupt acts, including by public officials, that frustrate the commencement or conducting of a proceeding, and not just acts that make evidence unavailable or impair its integrity.
So, those of you still here, I want you to know that previously there was someone from InfoWars. Yeah. There was a staffer. We don't know if he's a staffer, but we're pretty sure he worked for InfoWars. But he was wearing a Yale t-shirt, took it off somewhere before the show, during the show, to reveal his Hillary for President 2018 shirt. He's now gone. We're thankful for that. And like any sort of awful troll, we chased out with boring old facts. We said them, and he left with little to no fanfare. He's a sad man and shall continue to be so, much as we will continue to be sad as we read these awful facts that our president and his...
But also, we're in the home stretch, y'all.
Yeah, we're real close. Oh God, we're so close. We're like 20 minutes out.
Let's fess up. It is pages of throat clearing to explain why they don't actually prosecute.
Yeah. Oh yeah, absolutely.
But the benefit is we're now a little bit less anxious and loose. And to be fair,
we're gonna let it fly. Here we go. Section 512C2's breadth is, if you weren't done hearing about Section 512C2's breadth, is reinforced by the similarity of its language to the Omnibus Clause of 18 U.S.C. 1503, which covers, of course, anyone who corruptly obstructs or impedes or endeavors to influence, obstruct, or impede the due administration of justice. That clause of Section 1503 follows two more specific clauses that protect jurors, judges, and court officers. That omnibus clause has nevertheless been construed to be, quote, far more general in scope than the earlier clauses of the statute, end quote. United States v. Aguilar. Quote, the omnibus clause is essentially a catch-all provision which generally prohibits conduct that interferes with the due administration of justice, end quote. United States v. Brinson. As one court has explained, the omnibus clause, quote, prohibits acts that are similar in result rather than manner to the conduct described in the first part of the statute, end quote. While the specific clauses, quote, forbid certain means of obstructing justice, the omnibus clause aims at obstruction of justice itself, regardless of the means used to reach that result, end quote. Given the similarity of Section 512C2 to Section 1503's omnibus clause, Congress would have expected Section 1512C2 to cover acts that produced a similar result to the evidence impairment provisions, i.e., the results of obstructing justice, rather than covering only acts that were similar in manner. Read this way, Section 1512C2 serves a distinct function in the federal obstruction of justice statutes. It captures corrupt conduct, other than document destruction, that has the natural tendency to obstruct contemplated as well as pending proceedings. Here we have it, folks. There's a day. Section 1512C2 overlaps with other obstruction statutes, but it does not render them superfluous. Section 1503, for example, which covers pending grand jury and judicial proceedings, and Section 1505, which covers pending administrative and congressional proceedings, reach, quote, endeavors to influence, obstruct, or impede, end quote. The proceedings, a broader test for inchoate. We have an inchoate answer. Broader test for inchoate violations than Section 1512C2's, quote, attempt standard, which requires a substantial step towards a completed offense. See U.S. v. Sampson. Quote, efforts to witness tamper that rise to the level of an endeavor, yet fall short of an attempt, cannot be prosecuted under 512. U.S. v. Leisure. Oh, fuck you, U.S. I like having a good time. Collecting cases recognizing the difference between the endeavor and attempt standards. And the 18 U.S.C. subsection 1519, which prohibits destruction of documents or records in contemplation of an investigation or proceeding does not require the nexus showing under Aguilar, which section 1512C2 demands. See, for example, U.S. v. Yielding, quote, the requisite knowledge and intent under section 1519 can be present even if the accused lacks knowledge that he is or she is likely to succeed in obstructing the matter. United States v. Gray, in enacting subsection 1519, Congress rejected any requirement that the government prove a link between a defendant's conduct and imminent or pending official proceeding. End quote. The existence of an even substantial overlap is not, quote, uncommon. 1519, each reach conduct that section 1512 CT does not. The overlap provides no reason to give section 1512 an artificially limited construction.
Section 3. The legislative history of section 1512C2 does not justify narrowing its text. Quote, given the straightforward statutory command, end quote, in section 1512C2, there is no reason to resort to legislative history, end quote. U.S. v. Gonzalez. In any event, the legislative history of section 1512C2 is not a reason to impose extra textual limitations on its reach. Congress enacted section 1512C2 as part of the Sarbanes-Oxley Act. Sarbanes-Oxley Act of 2002. The relevant section of the statute was entitled, quote, tampering with a record or otherwise impeding an official proceeding, end quote. Emphasis the document, not me. That title indicates that Congress intended the two clauses to have independent effect. Section 1512C was added as a floor amendment in the Senate and explained as closing a certain, quote, loophole with respect to, quote, document shredding. But those explanations do not limit the enacted text. See Hilston Coal Group, B7. It is not, quote, it is not the law that a statute can have no effects which are not explicitly mentioned in its legislative history, end quote. See also Encino Motor Cars, LLC, v. Navarro.
Sorry.
Yeah, this is the rest of the night, everybody. Strap in. I hope you like case law.
I've been doing so well, I'm really holding it together. Okay. Quote, even if Congress did not foresee all the application of the statute, that is no reason not to give the statutory text a fair reading, end quote. The floor statements thus cannot detract from the meaning of the enacted text. See Barnhart v. Sigmund Coal Company. And, quote, floor statements from two senators cannot amend the clear and unambiguous language of a statute. We see no reason to give greater weight to the views of two senators than to the collective votes of both houses, which are memorialized in the unambiguous statutory text, end quote. That principle has particular force where one of the proponents of the amendment to section 1512 introduced his remarks as only, quote, briefly elaborating on some of the specific provisions contained in this bill, end quote.
Indeed, the language Congress used in section 1512C2, prohibiting corruptly obstructing, influencing, and impeding any official proceeding, or attempting to do so, parallels a provision that Congress considered years earlier in a bill designed to strengthen protections against witness tampering and obstruction of justice. While the earlier provision is not a direct antecedent of section 1512C2, Congress's understanding of the broad scope of the earlier provision is instructive, recognizing that, quote, proper administration of justice may be impeded or thwarted by a, quote, variety of corrupt methods limited only by the imagination of the criminally inclined. Congress considered a bill that would have amended section 1512 by making it a crime inter alia when a person, quote, corruptly influences, obstructs, or impedes the enforcement and prosecution of federal law, quote, administration of a law under which an official proceeding is being or may be conducted, quote, or the, quote, exercise of a federal legislative power of inquiry.
The Senate committee explained that The purpose of preventing an obstruction of or miscarriage of justice cannot be fully carried out by a simple enumeration of the commonly prosecuted obstruction offenses. There must also be protection against the rare type of conduct that is the product of the inventive criminal mind and which also thwarts justice.
Think ahead. The report gave examples of conduct, quote, actually prosecuted under the current residual clause, which would probably not be covered in this series of provisions without a residual clause. One prominent example was, quote, a conspiracy to cover up Watergate burglary and its aftermath by having the Central Intelligence Agency seek to interfere with an ongoing FBI investigation of the burglary. Why do you think he brought up that?
Great question.
Interesting question. Anyway, I don't know. The report, therefore, indicates a congressional awareness not only that residual clause language resembling Section 1512C2 broadly covers a wide variety of obstructive conduct, but also that such language reaches the improper use of governmental processes to obstruct justice, specifically the Watergate cover-up orchestrated by White House officials, including the president himself.
Just real quick, you said you talked about a miscarriage of justice, and I wonder if Georgia will also outlaw miscarriage of justice.
Very.
Thank you. This is going on my
Very likely. Stay tuned. Number 4, general principles of statutory construction do not suggest that Section 1512C2 is inapplicable to the conduct in this investigation.
What? Glad you got that out.
The requirement of fair warning in criminal law, the interest in avoiding due process, concerns in potentially vague statutes, and the rule of lenity do not justify narrowing the reach of Section 1512C2's text. A. As with other criminal laws, the Supreme Court has, quote, exercised restraint, unquote, in interpreting obstruction of justice provisions, both out of respect for Congress's role in defining crimes and in the interest of providing individuals with, quote, fair warning of what a criminal statute prohibits. In several obstruction cases, the court has imposed a nexus test that requires that the wrongful conduct targeted by the provision be sufficiently connected to an official proceeding to ensure the requisite culpability. Section 1512C2 has been interpreted to require a similar nexus. To satisfy the nexus requirement, the government must show as an objective matter that a defendant acted, quote, in a manner that is likely to obstruct justice, end quote, such that the statute, quote, excludes defendants who have an evil purpose but use means that would only unnaturally and improbably be successful, quote. Aguilar, quote, the endeavor must have the natural and probable effect of interfering with the due administration of justice, quote. The government must also show as a subjective matter that the actor, quote, contemplated a particular foreseeable proceedings, unquote. Those requirements alleviate fair warning concerns by ensuring that obstructive conduct has a close enough connection to existing or future proceedings to implicate the dangers targeted by the obstruction laws, and that the individual actually has the obstructive result in mind.
Oh, you did.
Oh, yes.
Case law might be.
Can I get a USB Aguilar?
I'm still really interested in the USB lead or what.
They buttoned it up. You have work to do.
Section D under general principles of statutory construction do not suggest that the Section 1512C2 is inapplicable. B. Courts also seek to construe statutes to avoid due process vagueness concerns. Vagueness doctrine requires that a statute define a crime, quote, with sufficient definiteness that ordinary people can understand what conduct is prohibited, and, quote, in a manner that does not encourage arbitrary and discriminatory enforcement. The obstruction statute's requirement of acting, quote, corruptly satisfies that test. Quote, acting corruptly within the meaning of 1512C2 means acting with improper purpose and to engage in that conduct knowingly and dishonestly with the specific intent to subvert, impede, or obstruct the relevant proceeding. The majority opinion in Aguilar did not address the defendant's vagueness challenge to the word corruptly, but Justice Scalia's separate opinion did reach that issue, which would have rejected the challenge. Scalia joined Kennedy and Thomas, concurring in part and dissenting in part. Statutory language need not be colloquial, Justice Scalia explained, and, quote, the term correctly, I know, in criminal laws, has a long-standing and well-accepted meaning. It denotes an act done with an intent to give some advantage inconsistent with official duty and the rights of others. Justice Scalia added that, in, quote, in the context of the obstructing jury proceedings, any claim of ignorance or of wrongdoing is incredible. Lower courts have also rejected vagueness challenges to the word, quote, corruptly. This well-established intent standard precludes the need to limit the obstruction statutes to only certain kinds of inherently wrong.
Only certain kinds.
Yes.
Subsection C. Finally, the rule of lenity, which I'm unfamiliar with, does not justify treating Section 1512C2 as a prohibition on evidence impairment as open to an omnibus clause. The rule of lenity is an interpretive principle that resolves ambiguity in criminal laws in favor of the less severe construction. Cleveland v. U.S. Quote, as the court has repeatedly emphasized, however, the rule of lenity applies only if, after considering text, structure, history, and purpose, there remains a grievous ambiguity of uncertainty in the statute, such that the court must simply guess as to what Congress intended. Abramsky v. U.S., if you know what I mean. The rule has been cited, for example, in adopting a narrow meaning of, quote, tangible object, end quote, in an obstruction statute, when the prohibition's title, history, and list of prohibited acts indicated a focus on destruction of records. C. Yates v. U.S., interpreting tangible objects in the phrase, quote, record document or tangible object, end quote, in 18 U.S.C. subsection 1519, to mean an item capable of recording or preserving information. Oh, Lordy, I hope there are tapes. Here, as discussed above, the text, structure, and history of section 1512C2, which we're all desperate to hear, leaves no, quote, grievous ambiguity, end quote, about the statute's meaning. Section 1512C2 defines a structurally independent general prohibition on obstruction of official proceedings. And that's that. Section 5. Other obstruction statutes might apply to the conduct of this investigation. Regardless whether Section 1512C2 covers all corrupt acts that obstructed, influence, or impede pending or contemplated proceedings, other statutes would apply to such conduct in pending proceedings, provided that the remaining statutory elements are satisfied, as discussed above. And ladies and gentlemen, there is a lot of above here. 5 facts previously above. Provided that the remaining statutory elements are satisfied. As discussed above, the omnibus clause in 18 U.S.C. 1503A applies generally to obstruction of pending judicial and grand proceedings. Section 1503A's protections extend to witness tampering and to other obstructive conduct that has a nexus to pending proceedings. And Section 1505 broadly criminalizes obstructive conduct aimed at pending agency and congressional proceedings. Finally, 18 U.S.C. subsection 1512B3 criminalizes tampering with witnesses to prevent the communication of information about a crime to law enforcement. The nexus inquiry articulated in Aguilar that an individual has, quote, knowledge that his actions are unlikely to affect the judicial proceeding, end quote, does not apply to section 1512B3. The nexus inquiry turns instead on the actor's intent to prevent communications to a federal law enforcement official. In sum, in light of the breadth of section 1512C2 and the other obstruction statutes, an argument that the conduct at issue in this investigation falls outside the scope of the obstruction laws lacks merit. If you follow
Subsection B, constitutional defenses to applying obstruction of justice statutes to presidential conduct. The president has broad discretion to direct criminal investigations. The Constitution vests the, quote, executive power in the president and enjoins him to, quote, take care that the laws be faithfully executed. Those powers and duties form the foundation of prosecutorial discretion. See U.S. v. Armstrong. Attorney General and U.S. attorneys, quote, have this latitude because they are designated by statute as the president's delegates to help him discharge his constitutional responsibility to, quote, take care that the laws be faithfully executed, end quote. The president also has authority to appoint officers of the U.S. and to remove those whom he has appointed. U.S. Constitution, Article 2, Subsection 2. Granting authority to the president to appoint all officers with the advice and consent of the Senate, but providing that Congress may vest the appointment of inferior officers in the president alone, the heads of departments, or the courts of law. See also Free Enterprise Fund v. Public Company Accounting Oversight Board, describing removal authority as flowing from the president's, quote, responsibility to take care that the laws be faithfully executed, which, side note, all of this, assumes the fact that this president cares at all about A, taking care, and B, faithfully executing any laws. Okay. Although the president has broad authority under Article 2, that authority coexists with Congress's Article 1 power to enact laws that protect congressional proceedings, federal investigations, the courts, and grand juries against corrupt efforts to undermine their functions. Usually, those constitutional powers function in harmony with the president enforcing the criminal laws under Article 2 to protect against corrupt, obstructive acts. But when the president's official actions come into conflict with the prohibitions in the obstruction statutes, any constitutional tension is reconciled through separation of powers analysis. The President's Counsel has argued that, quote, the President's exercise of his constitutional authority to terminate an FBI director and to close investigations cannot constitutionally constitute obstruction of justice. As noted above, no DOJ position or Supreme Court precedent directly resolves this issue. We did not find counsel's contention, however, to accord our reading of the Supreme Court authority addressing separation of powers. Applying the court's framework for analysis, we concluded that Congress can validly regulate the president's exercise of official duties to prohibit actions motivated by a corrupt intent to obstruct justice. The limited effect on presidential power that results from that restriction would not impermissibly undermine the president's ability to perform his Article 2 functions. So basically, Congress doing their job does not inappropriately conflict with division of powers, right? Separation of powers exists for accountability.
Section 1. The requirement of a clear statement to apply statutes to presidential conduct does not limit the obstruction statutes. Before addressing Article 2 issues directly, we consider one threshold statutory construction principle that is unique to the presidency. Quote, the principle that general statutes must be read as not applying to the president if they do not expressly apply where application would arguably limit the president's constitutional role. End quote. This, quote, clear statement rule, end quote, has its source in two principles. Statutes should be construed to avoid serious constitutional questions, and Congress should not be assumed to have altered the constitutional separation of powers without clear assurance that it intended that result. The Supreme Court has applied that clear statement rule in several cases. In one leading case, the court construed the Administrative Procedure Act not to apply to judicial review of presidential action. The court explained that it, quote, would require an express statement by Congress before assuming it intended the president's performance of his statutory duties to be reviewed for abuse of discretion, end quote. In another case, the court interpreted the word utilize in the Federal Advisory Committee Act, FACA, to apply only to the use of advisory committees established directly or indirectly by the government, thereby excluding the American Bar Association's advice to the Department of Justice about federal judicial candidates. The court explained that a broader interpretation of the term utilized in FACA would raise serious questions whether the statute, quote, infringed unduly on the president's Article II powers to nominate federal judges and violated the doctrine of separation of powers. Another case found that an established canon of statutory construction applied with, quote, special force to provisions that would impinge on the president's foreign affairs powers if construed broadly. Sale versus Haitian Centers Council, applying the presumption against extraterritorial application to construe the Refugee Act of 1980 as not governing in an overseas context where it could affect foreign and military affairs for which the president has unique responsibility. Phew. Huh?
Yeah. The Department of Justice has relied on this clear statement principle to interpret certain statutes as not applying to the president at all, similar to the approach taken in Franklin. Other OLC opinions interpret statutory text not to apply to certain presidential or executive actions because of constitutional concerns. But OLC has also recognized that this clear statement rule, quote, does not apply with respect to a statute that raises no separation of powers questions were it to be applied to the president, end quote, such as the federal bribery statute. OLC explained that, quote, application of subsection 201 raises no separation of powers question, let alone a serious one, because, unquote, because the Constitution confers no power in the president to receive bribes. In support of that conclusion, OLC noted constitutional provisions that forbid increases in the president's compensation while in office, quote, which is what a bribe would function to do, unquote, and the express constitutional power of, quote, Congress to impeach and convict a president for inter alia bribery, end quote. Under OLC's analysis, Congress can permissibly criminalize certain obstructive conduct by the president, such as suborning perjury, intimidating witnesses, or fabricating evidence, because those prohibitions raise no separations of powers questions. The Constitution does not authorize the president to engage in such conduct, and those actions would transgress the president's duty to, quote, take care that the laws be faithfully executed, unquote. U.S. Constitution Article 2, subsection 30. In view of those clearly permissible applications of the obstruction statutes to the president, Franklin's holding that the president is entirely excluded from a statute absent a clear statement would not apply in this context.
Kelly Bland, everybody. She has to leave. Give her a hand. Kelly, you're one of the best teachers I've ever met my entire life. Thank you so much for being here. We love you tons. Yeah, good luck to our
We are so close, and you all hear us.
We're doing this for us. Thanks for being on for the ride.
A more limited application appears of a clear statement rule to exclude from the obstruction statutes only certain acts by the president, for example, removing prosecutors or ending investigations for corrupt reasons, would be difficult to implement as a matter of statutory interpretation. It is not obvious how a clear statement rule would apply to an omnibus provision, like Section 1512C2, to exclude corruptly motivated obstructive acts, only when carried out in the president's conduct of office. No statutory term could easily bear that specialized meaning. For example, the word corruptly has well-established meaning and does not exclude exercises of official power for corrupt ends. Indeed, an established definition states that corruptly means actions with an intent to secure an improper advantage, inconsistent with official duty and the rights of others, end quote. And it would be contrary to ordinary rules of statutory construction to adopt an unconventional meaning of a statutory term only when applied to the president. See United States versus Santos. Rejecting a proposal to, quote, give the same word in the same statutory provision different meanings in different factual contexts. That doesn't make sense. That you should do that. Nor could such an exclusion draw on a separate and established background of interpretive presumption, such as the presumption against extraterritorial. Thank you. What they said applied in sale. the principle that courts will construe a statute to avoid serious constitutional questions, quote, is not a license for the judiciary to rewrite the language enacted by the legislature. Quote, it is one thing to acknowledge and accept well-defined or even narrowly enunciated generally applicable background principles of assumed legislative intent. It is quite another to espouse the broad proposition that criminal statutes do not have to be read as broadly as they are written, but are subject to a case-by-case exceptions. When proposed construction, quote, would thus function as an extra textual limit on the statute's compass, and quote, thereby preventing the statute from, quote, from applying to a host of cases falling within its clear terms, unquote, it is doubtful that the construction would reflect Congress's intent. That is particularly so with respect to obstruction statutes, which, quote, have been given broad and all-inclusive meaning. Accordingly, since no established principle of interpretation would exclude presidential conduct, we have investigated from statutes such as sections 1503, 1505, 12b, and 1512c2, we proceed to examine the separation of powers issues that could be raised as an Article II defense to the application of those statutes.
Thusly, Section 2, separation of powers, principles support the conclusion that Congress may validly prohibit corrupt, obstructed acts carried out through the President's official powers. Let me read that one more time for everybody, just so you can hear it. Separation of powers, principles support the conclusion that Congress may validly prohibit corrupt, obstructive acts carried out through the President's official powers.
So Congress can do its job and hold this motherfucker accountable.
Right. And if you're not clear what we mean, please keep the expertly cut out letters behind me. They say impeach. I know I tried to go like a cool young person there, and it did not work. Better than being that guy with an InfoWars shirt. When Congress imposes a limitation on the exercise of Article II powers, the limitation's validity depends on whether the measure, quote, disrupts the balance between the coordinate branches, end quote. Nixon v. Administrator of General Services. And I'm going to let you know, Nixon didn't win that one. Even when, quote, even when a branch does not arrogate power to itself, the separation of powers doctrine requires that a branch not impair another in the performance of its constitutional duties. End quote. Loving v. U.S.
Yes, Loving!
The, quote, separation of powers does not mean, end quote, however, quote, that the branches ought to have no partial agency in or no control over the acts of each other, end quote. In this context, the balancing test applies to assess separation of powers issues. Applying that test here, we concluded that Congress can validly make obstruction of justice statutes applicable to corruptly motivated official acts of the President without impermissibly undermining his Article II functions. We've spent 5.5 nights leading to this statement, so please let me say it again, and this is for you more than anyone else. As someone who's been here for every single night. We concluded that Congress can validly make obstruction of justice statutes applicable to corruptly motivated official acts of the President without impermissibly undermining his Article II functions. So anytime he claims Article II in allowing him to behave how he is, Mueller, lifetime public servant, determines with the benefit of the law that that is not okay, and that the Congress can make rules applying to his corrupt acts.
And in fact, it's their job.
Also, it's their fucking job. Subsection A, the Supreme Court's separation of powers balancing test applies in this context. A congressionally imposed limitation on presidential action is assessed to determine, quote, the extent to which it prevents the executive branch from accomplishing its constitutionally assigned functions, end quote. And if the, quote, potential for disruption is present, whether that impact is justified by an overriding need to promote objectives within the constitutional authority of Congress, end quote. That balancing test applies to a congressional regulation of presidential power through the obstruction of justice laws. When an Article 2 power has not been, quote, explicitly assigned by the text of the Constitution to be within the sole province of the President, but rather was thought to be encompassed within the general grant to the President of the executive power, end quote, the court has balanced competing constitutional considerations. As Justice Kennedy noted in Public Citizen, the court has applied a balancing test to restrictions on, quote, the President's power to remove executive officers, a power that is not conferred by any explicit provision in the text of the Constitution, as it is the appointment power, but rather is inferred to be necessary part of the grant of the executive power, end quote. Consistent with that statement, Morrison sustained, Jim, I assume, sustained a good cause limitation on the removal of an inferior officer with defined prosecutorial responsibilities, after determining that the limitation did not impermissibly undermine the President's ability to perform his Article 2 functions. The court has also evaluated other general executive power claims through a balancing test. For example, the court evaluated the President's claim of an absolute privilege for the presidential communications about his official acts by balancing that interest against the judicial branch's need for evidence in a criminal case. United States v. Nixon Supra, recognizing a qualified constitutional privilege for presidential communications on official matters. The court has also upheld a law that provided for archival access to presidential records despite a claim of absolute presidential privilege over the records. The analysis in those cases supports applying a balancing test to assess the constitutionality of applying the obstruction of justice statutes to presidential exercises of executive power.
Only in a few instances has the court applied a different framework. When the president's power is, quote, both exclusive and conclusive on the issue, and, quote, Congress is precluded from regulating its exercise. In Zivotofsky, for example, the court followed, quote, Justice Jackson's familiar tripartite framework, end quote, in Youngstown Sheet and Tube Company v. Sawyer, and held that the president's authority to recognize foreign nations is exclusive. See also Public Citizen. Citing the power to grant pardons under U.S. Constitutional Article 2, subsection 2, and the presentment clauses for legislation, U.S. Constitution Article 1, section 7, as examples of exclusive presidential powers by virtue of constitutional text. But even when a power is exclusive, quote, Congress's powers and its central role in making laws give it substantial authority regarding many of the policy determinations that precede and follow, end quote, the President's Act. For example, although the President's power to grant pardons is exclusive and not subject to congressional regulation, Congress has the authority to prohibit the corrupt use of, quote, anything of value, end quote, to influence the testimony of another person in a judicial, congressional, or agency proceeding, which would include the offer or promise of a pardon to induce a person to testify falsely or not to testify at all.
Sounds familiar.
Yeah. The offer of a pardon would precede the act of pardoning and thus be within Congress's power to regulate even if the pardon itself is not. Just as the speech or debate clause absolutely protects legislative acts, but not a legislator's, quote, taking or agreeing to take money for a promise to act in a certain way, for it is taking the bribe, not performance of the illicit compact, that is a criminal act, end quote. The promise of a pardon to corruptly influence testimony would not be a constitutionally immunized act. The application of obstruction statutes to such promises, therefore, would raise no serious separation of powers issues.
Subtext, impeach.
Okay. Subsection B. The effect of obstruction of justice statutes on the President's capacity to perform his Article 2 responsibilities is limited. Under the Supreme Court's balancing test for analyzing separation of powers issues, the first task is to assess the degree to which applying obstruction of justice statutes to presidential actions affect the President's ability to carry out his Article 2 responsibilities. As discussed above, applying obstruction of justice statutes to presidential conduct that does not involve the president's conduct in office, such as influencing the testimony of witnesses, is constitutionally unproblematic. The president has no more right than other citizens to impede official proceedings by corruptly influencing witness testimony. The conduct would be equally improper whether it effectuated through direct efforts to produce false testimony or suppress the truth, or through the actual threatened or promised use of official powers to achieve the same results. The president's action in curtailing criminal investigations, or prosecutions, or discharging law enforcement officials raises different questions. Each type of action involves the exercise of executive discretion in furtherance of the president's duty to take care that the laws be faithfully executed. Congress may not supplant the president's exercise of executive power to supervise prosecutions or to remove officers who occupy law enforcement positions. See Boucher v. Sinon. Congress cannot reserve for itself the power of removal of an officer charged with the execution of the laws except by impeachment, because the structure of the Constitution does not permit Congress to execute the laws. This kind of congressional control over the execution of the laws is constitutionally impermissible. End quote. Yet the obstruction of justice statute does not aggrandize power in Congress or usurp executive authority. Instead, they impose a discrete limitation on conduct only when it is taken with the corrupt intent to obstruct justice. The obstruction statutes thus would restrict presidential action only by prohibiting the president from acting to obstruct official proceedings for the improper purpose of protecting his own interests.
Oh, whoa. That's right now.
Yeah, I get it. The direct effect on the president's freedom of action would correspondingly be a limited one. A preclusion of, quote, corrupt official action is not a major intrusion on Article 2 powers. For example, proper supervision of criminal law does not demand freedom for the president to act with the intention of shielding himself from criminal punishment, avoiding financial liability, or preventing personal embarrassment. To the contrary, a statute that prohibits official action undertaken for such personal purposes furthers, rather than hinders, the impartial and even-handed administration of the law. And the Constitution does not mandate that the president have unfettered authority to direct investigations or prosecutions with no limits whatsoever in order to carry out his Article 2 functions. He's not a king. See Heckler v. Cheney, Congress may limit an agency's exercise of enforcement powers if it wishes, either by setting substantive priorities or by otherwise circumscribing an agency's power to discriminate among issues or cases it will pursue. U.S. v. Nixon, quote, to read the Article 2 powers of the president as providing an absolute privilege to withhold confidential communications from a criminal trial would upset the constitutional balance of a workable government and greatly impair the role of the courts under Article 3. Nor must the president have unfettered authority to remove all executive branch officials involved in the execution of the laws. The Constitution establishes that Congress has legislative authority to structure the executive branch by authorizing Congress to create executive departments and officer positions and to specify how inferior officers are appointed. For example, U.S. Constitution Article 1, subsection 8, clause 18, necessary and proper clause, Article 2, subsection 2, clause 1, opinions clause, Article 2, subsection 2, clause 2, appointments clause. While the president's removal power is an important means of ensuring that officers faithfully execute the law, Congress has a recognized authority to place certain limits on removal.
I'd like to point again to our sign.
I'm sensing a key.
Yeah. Now, the president's removal powers are at their zenith with respect to principal officers, that is, officers who must be appointed by the president and who report to him directly. The president's exclusive and illimitable power of removal of those principal officers furthers, quote, the president's ability to ensure that the laws are faithfully executed, unquote. Thus there are some purely executive officials who must be removable by the president at will if he is able to accomplish his constitutional role, unquote. See Morrison, quote, the president's cabinet officers must do his will, and, quote, the moment that he loses confidence in the intelligence, ability, judgment, or loyalty of any of them, he must have the power to remove them without delay. See Humphrey's Executor versus the United States. Congress has the power to create independent agencies headed by principal officers removable only for good cause. In light of those constitutional precedents, it may be that the obstruction statutes could not be constitutionally applied to the removal of a cabinet officer, such as Attorney General. In that context, at least absent circumstances showing the President was clearly attempting to thwart accountability for personal conduct while evading ordinary political checks and balances, even the highly limited regulation imposed by the obstruction statutes could possibly intrude too deeply on the President's freedom to select and supervise the members of his cabinet. The removal of inferior officers, in contrast, need not necessarily be at the will of the President to fulfill his constitutionally assigned role in managing the executive branch. Quote, inferior officers are officers whose work is directed and supervised at some level by other officers appointed by the President with the Senate's consent. The Supreme Court has long recognized Congress's authority to place for-cause limitations on the President's removal of quote, inferior officers whose appointment may be vested in the head of a department. See United States versus Perkins. Quote, the constitutional authority in Congress to thus vest the appointment of inferior officers in the heads of departments implies authority to limit, restrict, and regulate the removal by such laws as Congress may enact in relation to officers so appointed. The category of inferior officers includes both the FBI director and the special counsel, each of whom reports to the Attorney General. Their work is thus, quote, directed and supervised by a presidentially appointed Senate-confirmed officer. See NRE, grand jury investigation. Quote, holding that the special counsel is an, quote, inferior officer for the constitutional purposes.
Where the Constitution permits Congress to impose a good cause limitation on the removal of an executive branch officer, the Constitution should equally permit Congress to bar removal for the corrupt purpose of obstructing justice, limiting the range of permissible reasons for removal to exclude a, quote, corrupt purpose imposes a lesser restraint on the President than requiring an affirmative showing of good cause. It follows that for such inferior officers, Congress may constitutionally restrict the President's removal authority if that authority was exercised for the corrupt purpose of obstructing justice. See firing of Coon. And even if a particular inferior officer's position might be of such importance to the execution of the laws that the President must have at-will removal authority, the obstruction of justice statutes could still be constitutionally applied to forbid removal for a corrupt reason. A narrow and discrete limitation on removal that precluded corrupt action would leave ample room for all other considerations, including disagreement over policy or loss of confidence in the officer's judgment or commitment. A corrupt purpose prohibition, therefore, would not undermine the President's ability to perform his Article II functions. Accordingly, because the separation of powers question is, quote, whether the removal restrictions are of such nature that they impede the President's ability to perform his constitutional duty, in quote Morrison, a restriction on removing an inferior officer for a corrupt reason, a reason grounded in achieving personal rather than official ends, does not seriously hinder the President's performance of his duties. The President retains broad latitude to supervise investigations and remove officials, circumscribed in this context only by the requirements that he not act for corrupt personal purposes. I'm going to, which one? I have a footnote. And before I read that footnote, let me read this last sentence again. The President retains broad latitude to supervise investigations and remove officials, circumscribed in this context only by the requirement that he not act for corrupt personal reasons. If I was going to give this administration an epitaph, it would be corrupt personal reasons. Footnote 1089. the obstruction statutes do not disqualify the president from acting in a case simply because he has a personal interest in it or because his own conduct may be at issue. As the Department of Justice has made clear, a claim of a conflict of interest, standing alone, cannot deprive the president of the ability to fulfill his constitutional function. See UGO, Office of Legal Counsel, application of, there's a whole bunch of that, and I will not read further from it. Subsection C. Congress has power to protect congressional, grand jury, and judicial proceedings against corrupt acts from any source where a law imposes a burden on the president's performance of Article 2 functions. Separation of powers analysis considers whether the statutory measure, quote, is justified by an overriding need to promote objectives within the constitutional authority of Congress, end quote. Here, Congress enacted the obstruction of justice statutes to protect, among other things, the integrity of its own proceedings, grand jury investigations, and federal criminal trials. Those objectives are within Congress's authority and serve strong governmental interests. Congress has Article 1 authority to define generally applicable criminal law and apply it to all persons, including the president. Congress clearly has authority to protect its own legislative functions against corrupt efforts designed to impede legitimate fact-gathering and lawmaking efforts. Congress also has authority to establish a system of federal courts, which includes the power to protect judiciary against obstructive acts. See U.S. Constitution, Article 1, subsection 8, quote, the Congress shall have power to constitute tribunals inferior to the Supreme Court, end quote, and, quote, to make all laws which shall be necessary to proper for carrying into execution the foregoing powers, end quote. The long lineage of the obstruction of justice statutes, which can be traced to at least 1831, attests to the necessity for that protection. See an act declaratory of the law concerning contempt of court, making it a crime if, quote, any person or persons shall corruptly endeavor to influence, intimidate, or impede any juror, witness, or officer in any court of the United States in the discharge of his duty, or shall corruptly obstruct or impede, or endeavor to obstruct or impede the due administration of justice therein, end quote.
Section 2. The Article 3 courts have an equally strong interest in being protected against obstructive acts, whatever their source. As the Supreme Court explained in U.S. v. Nixon, a, quote, primary constitutional duty of the judicial branch, end quote, is to, quote, do justice in criminal prosecutions, end quote. In Nixon, the court rejected the president's claim of absolute executive privilege because, quote, the allowance of the privilege to withhold evidence that is demonstrably relevant in a criminal trial would cut deeply into the guarantee of due process of law and gravely impair the basic function of the courts, end quote. As Nixon illustrates, the need to safeguard judicial integrity is a compelling constitutional interest. See at 709, the above at 709, noting that the denial of full disclosure of the facts surrounding relevant presidential communication threatens, quote, the very integrity of the judicial system and public confidence in the same system, end quote. Section 3. Finally, the grand jury cannot achieve its constitutional purpose absent protection from corrupt acts. Serious federal criminal charges generally reach the Article 3 courts based on an indictment issued by a grand jury. Cobbledick v. Eunice. Cobbledick, I can't, I've lost it. Cobbledick v.
Oswald Cobbledick,
versus the United States. Quote, the Constitution itself makes the grand jury a part of the judicial process, end quote. And the grand jury's function is enshrined in the Fifth Amendment. Quote, no person shall be held to answer, end quote, for serious crime, quote, unless on a presumption or indictment of a grand jury, end quote. Quote, the whole theory of the grand jury's function is that it belongs to no branch of the institutional government, serving as a kind of buffer or referee between the government and the people, end quote. U.S. v. Williams. Quote, pledged to indict no one because of prejudice and to free no one because of special favor, end quote. Costello v. U.S. If the grand jury were not protected against corrupt interference from all persons, its function as an independent charging body would be thwarted, and an impartial grand jury investigation to determine whether probable cause exists to indict is vital to the criminal justice process.
The final step in the constitutional balancing process is to assess whether the separation of powers doctrine permits Congress to take action within its constitutional authority, notwithstanding the potential impact on Article II functions. In the case of the obstruction of justice statutes, our assessment of the weighing of interests leads us to conclude that Congress has the authority to impose the limited restrictions contained in those statutes on the President's official conduct to protect the integrity of important functions of other branches of government. A general ban on the corrupt action does not unduly intrude on the President's responsibility to take care that the laws be faithfully executed. To the contrary, the concept of faithful execution connotes the use of power in the interest of the public, not in the office holder's personal interest. See 1 Samuel Johnson, A Dictionary of the English Language. Faithfully, defined 3 with strict adherence to duty and allegiance.
Yeah.
Samuel Johnson. And immunizing the President from the generally applicable criminal prohibition against corrupt obstruction of official proceedings would seriously impair Congress's power to enact laws to promote objectives within its constitutional authority, i.e., protecting the integrity of its own proceedings and the proceedings of Article III courts and grand juries. Accordingly, based on the analysis above, we were not persuaded by the argument that the President has blanket constitutional immunity to engage in acts that would corruptly obstruct justice through the exercise of otherwise valid Article II powers.
No.
Yeah, eat it up. Oh, and there's a footnote on this one, 1091. A possible remedy through impeachment for abuses of power would, suggesting a possible remedy through impeachment for abuses of power would not substitute for potential criminal liability after a president leaves office.
So both and.
Impeach him and then prosecute him after he's out of office.
Yes, exactly. Impeachment would remove a president from office, but would not address the underlying culpability of the conduct or serve the usual purposes of the criminal law. Indeed, the impeachment judgment clause recognizes that criminal law plays an independent role in addressing officials, distinct from the political remedy of impeachment. Impeachment is also a drastic and rarely invoked remedy. Congress is not restricted to relying only on impeachment, rather than making criminal law applicable to a former president, as OLC has recognized.
Well, no. That's fine.
Okay.
What I would need.
My last little section. Okay, subsection 3. Ascertaining whether the president violated the obstruction statutes would not shill his performance of his Article II duties. Applying the obstruction statutes to the president's official conduct would involve determining as a factual matter whether he engaged in an obstructive act, whether the act had a nexus to official proceedings, and whether he was motivated by corrupt intent. But applying those standards to the president's official conduct should not hinder his ability to perform his Article II duties. CF makes the need for obscurity, taking into account chilling effect on the president in adopting a constitutional rule of presidential immunity from private civil damages action based on official duty. Several safeguards would prevent a chilling effect: the existence of settled legal standards, presumption of regularity in prosecutorial actions, and the existence of evidentiary limitations on proving the president's motives. And historical experience confirms that no impermissible chill should exist. A. As an initial matter, the term corruptly sets a demanding standard. It requires a concrete showing that a person acted with an intent to obtain an improper advantage for himself or someone else, inconsistent with official duty and the rights of others. That standard parallels the president's constitutional obligation to ensure the faithful execution of the laws. And virtually everything the president does in the routine conduct of office will have a clear governmental purpose and will not be contrary to his official duty. Accordingly, the president has chilled in those actions because in virtually all instances, there will be no credible basis for suspecting a corrupt personal motive. That point is illustrated by examples of conducts that would and would not satisfy the stringent corrupt motive standard. Direct or indirect action by the president to end a criminal investigation into his own or his family members' conduct to protect against personal embarrassment or legal liability would constitute a core example of corruptly motivated conduct. So too would action to halt an enforcement proceeding that directly and adversely affected the president's financial interests for the purpose of protecting those interests. In those examples, official power is being used for the purpose of protecting the president's personal interests. In contrast, the president's actions to serve political or policy interests would not qualify as corrupt. The president's role as head of the government necessarily requires him to take into account political factors in making policy decisions that affect law enforcement actions and proceedings. For instance, the president's decision to curtail a law enforcement investigation to avoid international friction would not implicate the obstruction of justice statutes. Criminal law does not seek to regulate the consideration of such political or policy factors in the conduct of government. And when legitimate interests animate the president's conduct, those interests will almost invariably be readily identifiable based on objective factors. Because the president's conduct in those instances will obviously fall outside the zone of obstruction of law, no chilling concern should arise.
B. There is no reason to believe that investigations, let alone prosecutions, would occur except in highly unusual circumstances when a credible factual basis exists to believe that obstruction occurred. Prosecutorial action enjoys a presumption of regularity. Absent, quote, clear evidence to the contrary, courts presume that prosecutors have properly discharged their official duties. The presumption of prosecutorial regularity would provide even greater protection to the president than exists in routine cases given the prominence and sensitivity of any matter involving the president, and the likelihood that such matters will be subject to thorough and careful review at the most senior levels of the Department of Justice. Unfortunately, that's a go hard. Under OLC's opinion that a careful review, that a sitting president is entitled to immunity from indictment, only a successor administration will be able to prosecute a former president. But that consideration does not suggest that a president would have any basis for fearing abusive investigations or prosecutions after leaving office. There are, quote, obvious political checks, end quote, against initiating a baseless investigation or prosecution of a former president. And the Attorney General holds, quote, the power to conduct the criminal litigation of the United States government, end quote, United States versus Nixon, which provides a strong institutional safeguard against politicized investigation or prosecutions. These considerations distinguish the Supreme Court's holding in Nixon versus Fitzgerald that, in part because inquiries into the president's motives would be, quote, highly intrusive, the president is absolutely immune from private civil damages, actions based upon his official conduct, civil damages actions based upon his official conduct. As Fitzgerald recognized, there is a lesser public interest in actions for civil damages than, for example, in criminal prosecutions. And private actions are not subject to the institutional protections of an action under the supervision of the Attorney General and subject to a presumption of regularity.
C. In the rare cases in which a substantial and credible basis justifies conducting an investigation of the president, the process of examining his motivations to determine whether he acted for a corrupt purpose need not have a chilling effect. Ascertaining the president's motivations would turn on any explanation he provided to justify his actions. The advice he received, the circumstances surrounding the actions, and the regularity or irregularity of the process he employed to make decisions. But grand juries and courts would not have automatic access to confidential presidential communications on those matters. Rather, they could be presented in official proceedings only on a showing of sufficient need. In any event, probing the president's intent in a criminal matter is unquestionably constitutional in at least one context. The offense of bribery turns on the corrupt intent to receive a thing of value in return for being influenced in official action. There can be no serious argument against the president's potential criminal liability for bribery, offenses notwithstanding the need to ascertain his purpose and intent. Quote, application of subsection 201 to the president raises no separation of powers issue, let alone a serious one. End quote. D. Finally, history provides no reason to believe that any asserted chilling effect justifies exempting the president from the obstruction laws. As a historical matter, presidents have very seldom been the subjects of grand jury investigations, and it is rarer still for circumstances to raise even the possibility of a corrupt personal motive for arguably obstructive action through the president's use of official power. Accordingly, the president's conduct of office should not be chilled based on hypothetical concerns about the possible application of a corrupt motive standard in this context. In sum, contrary to the position taken by the President's counsel, we concluded that, in light of the Supreme Court precedent governing separation of powers issues, we had a valid basis for investigating the conduct at issue in this report. In our view, the application of the obstruction statutes would not permissibly burden the president's performance of his Article 2 function to supervise prosecutorial conduct or to remove inferior law enforcement officers, and the protection of the criminal justice system from corrupt acts by any person, including the president, accords with the fundamental principle of our government that, quote, no person in this country is so high that he is above the law.
Oh, yeah. 4. Conclusion. This is the conclusion to the Mueller Report.
It's fire under it. It's good.
Hell yeah. Because we determined not to make a traditional prosecutorial judgment, we did not draw ultimate conclusions about the president's conduct. The evidence we obtained about the president's actions and intent presents difficult issues that would need to be resolved if we were making a traditional prosecutorial judgment. At the same time, if we had confidence after a thorough investigation of the facts that the president clearly did not commit obstruction of justice, we would so state. Based on the facts and the applicable legal standards, we are unable to reach that judgment. Accordingly, while this report does not conclude that the president committed a crime, it also does not exonerate him.
That's the end! That's the Mueller Report! Holy shit! To summate, impeach. We're not saying that the Senate needs to make a decision one way or the other. We're saying that an investigation into the president's behavior needs to be fully conducted through an open impeachment inquiry through the the House Judiciary Committee. Is the one who starts the impeachment inquiry, and we go from there. That's all we want.
So the very best thing that each of us can do right now is call, write letters of pressure, our members of Congress, but particularly our members of the House, to join that inquiry.
Even if it's Chip Roy.
Well, and also share that message and priority and best action with your friends and family, particularly those who live in districts of Democratic members of Congress. Let's get everyone on board with this.
Call your peeps, y'all. Thanks for coming out. If you haven't closed your tab, please tip the bartenders. They're using so much free.
If you want to buy some books, we'll be over there with a reader for it. Feel free to pick up some free gear. And if you haven't already, sign up for an email list.
Thank you, Sarah. Thank you, Shannon. Thank you, Hildeland. Thank you, Tony Weber. My name is David Higgins, and we are now done reading the Mueller Report.